everybody. Glad to be back with you again. Today, I want to discuss with you the Pacheco case. The Pacheco case is very interesting to us in the structured settlement industry and the settlement planning industry because it's the first case on record where the plaintiff attorney successfully negotiated for his client to have his own settlement planning expert and for that expert to be solely responsible for the selection of the companies that would provide the funding vehicles. Once the settlement was finalized, the defendant casualty company reneged. And this has happened more than on one occasion. Perhaps it's even happened to you in your case, or cases before. You reach a settlement negotiation, and the defendants decide to go back on the deal by trying to reopen the negotiations and impose conditions of settlement like you must use our structured settlement broker if you want a structured settlement, you must use our choice of company, you must use even our own wholly owned affiliate. In the Pacheco case, what was interesting here is that CNA Insurance agreed to the plaintiff's demands at settlement and the conditions of settlement from the plaintiff that said, we have our own specialist, he'll be the only specialist involved, we do not want your specialist involved in our client's financial planning, and we will have access to the full market for funding vehicles, annuities, etc. for our client, and will not be limited in choices. Settlement agreement was reached, the checks were requested, and then CNA said, no, you must use our broker and you must place the annuity with our annuity company. So what did the plaintiff attorney do that was so powerful? He simply filed an emergency motion with the court asking for show cause from the defendants as to why they would not fund the settlement as they had agreed to at the time of the ending of the settlement negotiations. The court sided with the plaintiffs. They came down so hard on the defendants that they ordered CNA to pay 1 month's missed annuity payment out of their own pocket, in addition to fully funding the annuity as promised, with the company of the plaintiff's choosing and through the settlement planning expert that the plaintiff had chosen. And the court specifically said that the plaintiff's expert would be the only expert and that CNA would fund all of this in a timely fashion and then pay the plaintiff's settlement planner a fee for the time and effort he put in to help the attorney prepare for the motion and order to the court with some specific testimony and exhibits. So this was a well-negotiated case. It's a case where the usage of a stipulation of settlement came in handy. We'll cover that in our next newsletter, and that's something that I think you're going to want to know about too. But in the meantime, attached to this edition of our e-letter is a copy of the emergency motion and then the order in the Pacheco case. If you have any questions about this, or if it's a little grainy or unreadable, let us know and we'll try to get you a better copy by fax or mail. But see if this doesn't help you the next time the defendants renege on what they've agreed to do at settlement. Thanks. See you next time.